U.S. Supreme Court issued a major ruling on Friday, the 28th of June, 2025, siding with the Trump administration by limiting the authority of federal district courts to impose nationwide injunctions. The decision stems from legal challenges to an executive order issued by former President Donald Trump, aimed at restricting birthright citizenship. Under this executive order, children born in the U.S. on or after February 19, 2025, will not be granted U.S. citizenship unless at least one parent is either a U.S. citizen or a lawful permanent resident. However, the ruling doesn't allow for uniform nationwide enforcement. The Supreme Court concluded that federal district judges can only block federal actions within their own jurisdictions. Since 22 states and the District of Columbia successfully challenged the order, the policy remains blocked in those areas. The federal government can proceed with enforcement in the remaining 28 states. This creates a fragmented situation. A child's eligibility for citizenship now depends on the state in which they are born. This outcome is completely irrational, said Letty Volpe, a law professor at UC Berkeley. States outside of the legal challenges could face pressure to deny citizenship, creating unequal treatment for families. Who is affected by the executive order? Trump's executive order, signed on January 20, 2025, states that the federal government will no longer issue official proof of citizenship, such as a passport or social security number, for babies born in the U.S. after February 19th if the biological mother is undocumented and the father is neither a citizen nor a permanent resident. The mother holds a temporary immigration status, and the father is not a citizen or permanent resident. This could impact families where both parents are undocumented. Both parents have only temporary legal status, such as TPS, DACA, H-1B, J-1 student, or H-2A agricultural visas. One parent is undocumented and the other has temporary legal status. Where is the order blocked? The executive order cannot be enforced in the following 22 states in the District of Columbia: California, Arizona, Colorado, Connecticut, Delaware, Hawaii, Illinois, Maine, Massachusetts, Maryland, Michigan, Minnesota, Nevada, New Jersey, New Mexico, New York, North Carolina, Oregon, Rhode Island, Vermont, Washington, Wisconsin. For example, a baby born to undocumented parents in Oregon on July 1st will still be considered a U.S. citizen. In contrast, a child born under the same conditions in Texas may not be. There's now the potential for the same child to be recognized as a citizen in one state, but not in another, said Ming H. Chen, a professor at UC Law San Francisco. This inconsistency creates uncertainty for families, institutions, and government agencies. Legal and social backlash. Critics say the decision undermines core American values. It's unfair that your place of birth within the U.S. can determine your citizenship status, said Annie Lee, policy director at Chinese for Affirmative Action. This threatens the very foundation of what citizenship means. What if you're expecting a baby? Babies born before February 19, 2025, are not affected by this policy and remain U.S. citizens regardless of their parents' immigration status. No one will lose existing citizenship as a result of this order. If you're expecting a child after February 19th, the outcome depends on both where you give birth and how ongoing lawsuits unfold. While the Supreme Court has allowed enforcement in 28 states, it has not yet ruled on whether the executive order is constitutional. Several cases are still pending that may ultimately determine whether the policy is upheld or overturned across the country. There's a chance the Supreme Court could find this order unconstitutional, said Lee. But in the meantime, what happens to the children born in this legal limbo? Governors and attorneys general in the 28 states where the order is enforceable may soon issue further guidance on how birth records and documentation will be handled.